Welcome to this instruction video on a trusted legal framework. My name is Erik Rodemach, I'm Program Coordinator for ITEA. In this picture you see an overview of the trusted legal framework. Why do we call it a trusted legal framework? The reason behind this is that this legal framework was already used from this very beginning of ITEA, in the ITEA Program 1, in the ITEA Program 2 and now also in the ITEA Program 3. And the fact is that this legal framework worked very well for all our projects and we never had any issues with this. So that's why we call it a trusted legal framework. Now let's have a look how it works and what are the main items in here. First of all, you see in the middle the different steps, the different phases of the project. First of all, we have the project outline preparation event, then we have the project outline preparation itself. The next step is the full project proposal preparation with the full project proposal as a result. When the ITEA label, when the ITEA 3 label is assigned to this project, then finally the project will start and have its project lifetime. At the bottom you see a line indicating the different bodies, the ITEA bodies, including the ITEA board, the ITEA board support group and the ITEA steering group, as well as the ITEA office. All these people represented in these bodies have signed a non-disclosure, a declaration of non-disclosure. And this declaration of non-disclosure indicates that they are not allowed to disclose any information about your projects to the outside world. If we look at the first step of the projects, which is the project outline preparation event, this is an event where a lot of people gather together to present their project ideas and also to start initiating some first consortia. Of course, these people do not want to spread their project ideas too easily to the outside world, and therefore we ask all participants participating to this event to sign a so-called non-disclosure agreement. Then in the next step we will have the project outline preparation leading to the project outline. As soon as this project outline is delivered and submitted to ITEA, we ask the partners of the project to sign a letter of intent. This letter of intent needs to be signed by the authorized representative of the partners. And this indicates that these partners are really serious to participate in this project. The third step is the full project proposal preparation, leading to a full project proposal. When the full project proposal has been submitted, the project partners are obliged to sign a declaration of acceptance, the so-called DOA. With this declaration of acceptance, they declare that they accept the rules and regulations as they are laid down in the ITEA frame agreement. This ITEA frame agreement, which you will see on the top of this picture, is the contract, the agreement between the ITEA founding companies when ITEA 3 was founded. Finally, when the ITEA 3 label is given to this project, the project lifetime will start of the project. And of course, cooperation needs to be assured in a legal way as well. Therefore, we initiated the Project Cooperation Agreement, the so-called PCA. This project cooperation needs to be set up by the project partners and also signed by all the project partners, and forms a legal framework also to work within the project. We will come back to this in a later slides. Let's have a first look at the ITEA frame agreement. The ITEA frame agreement, as I mentioned, is the official agreement between the ITEA founding partners. This was initiated at the beginning of ITEA 3, and it's a long legal process to produce this ITEA frame agreement and to have it signed finally by all these partners. Therefore, the ITEA frame agreement can be considered as a stable and document which will only be revised in a very exceptional cases. In fact, this hardly ever happens. All other non-founding ITEA project partners agree with the rules laid down in the IFA by signing a declaration of acceptance, a DOA, for each project. This was done because it's practically impossible to have everyone signing the ITEA frame agreement. That would cause a tremendous overhead. So this is the way that we found as a workable solution. Signing a DOA is obliged when partners want to participate in an ITEA project. If you do not sign the DOA, you're not allowed to participate in an ITEA project. The IFA, the ITEA Frame Agreement, contains 12 articles with generic ITEA rules. The rules are further detailed in the ITEA Rules and Regulations and in several other guidelines which you can find on the ITEA community website. The cooperation within a project is further detailed in a specific cooperation agreement, the PCA, as I mentioned it before, which makes references to the IFA. So you see there is a close link between the documents as well. The content of the ITEA Frame Agreement. There is a list of the ITEA founding companies, preamble, and then the articles start. First of all, the definitions, the scope of ITEA, the executive bodies, being the board, the BSG, and the steering group. A session of further parties. Of course, Article 5, projects and proposals in ITEA. And Article 6, the proposal evaluation in the ITEA label. Article 7 describes the cost of the ITEA organization. Article 8, confidentiality, restriction in use. Article 9, very important, the intellectual property rights and licensing. Then Article 10, warranty and liability. Article 11, duration and termination. And Article 12, miscellaneous issues. Then there is 2 annexes. First of all, the deed of accession when new board members want to join ITEA 3. Then Annex B is the declaration of acceptance for ITEA 3 project partners. This form can also be downloaded from the ITEA website separately by partners. Okay, let's have a look more in detail in some of the articles. Starting with Article 7, cost of ITEA organization. As it's stated in this article, the costs which are covered in the approved annual budget shall be borne by all funded ITEA 3 partners, relative to the planned effort and cost of their labeled ITEA 3 projects in the respective year. So that means that partners which do get public funding from their authorities are obliged to contribute to ITEA by paying these costs. By participating and signing the DOA, partners agree to pay the annual contribution fee. So if you sign the DOA, you also agree to pay the annual contribution fee here. Detailed contribution rules are further specified in the ITEA contribution rules. Article 9, intellectual property rights and licensing. The generic rules are defined in the IFA but can be partly overruled and will be further customized in the PCA. The access rights rules are defined for 2 cases. First of all, execution within the projects, and secondly, for commercial use. We have clarified this a little bit more into the next slide. This slide gives you a simplified summary of the IPR rules in the frame agreement and the PCA as well. First of all, every partner gets full ownership of the IPR it generates. There is no discussion about this. Every partner keeps full ownership of its background. So every IPR which you bring into your project and which you already had in possession, you will keep that. If one partner needs access to the background of another partner, this has to be agreed in the PCA. IPR access and licensing between the project partners is described in the table then below. Here you see in the different columns the IPR. First of all, we identify IPR within the project, so for R&D, and secondly for commercial exploitation. And then we have the two other columns. First of all, the foreground IPR, which is the IPR which is generated during the project, and the background IPR, which is brought into the project by partners who already possessed this IPR. If we look first for the IPR to be used within the project and during the project. Concerning the foreground IPR, this IPR can be used by other partners where needed. And this is always done on a royalty-free base. Background IPR is always used where agreed to be needed and if the owning partner is free to disclose this. And also this background IPR is provided royalty-free. Then IPR for commercial exploitation, so that means after the project and really used in commercial products. Then the foreground IPR can be used by other partners, and this has to be agreed in the PCA. First of all, when it's balanced, when the contribution of the partners is balanced, this can be based on a royalty-free basis. If the contribution is not balanced, as indicated in the PCA, then other partners can use the IPR on a fair and reasonable conditions. For the background, other partners can use this where agreed to be needed and if the owning partner is free to disclose it. And here it always concerns that it's under fair and reasonable conditions, which can be used by the other partners. Now let's have a look at the Project Cooperation Agreement. This is the specific agreement signed by the project partners in the project, and this forms the basis for the legal basis for their cooperation. It is an agreement among the project partners. The project leader is responsible to initiate and process the customization and signature of the PCA. We provide a template for the PCA, but you can customize this PCA still in a limited way. The ITEA office is not needed to receive a copy of the PCA, but we will monitor the signature during the project reviews. ITEA provides a Pca template. This template was created by the legal representatives of the ITEA founding companies, and it took quite a long time to agree on all the articles, and this is finally the outcome of this PCA. It indicates also that it's kind of trusted template. We recommend therefore to use this template. Adaptation of the template, which is possible, might lead to considerable delays of the final signature, because also then the legal representatives of the partners need to agree on this new template. The content of the Pca template, it consists of the first article, the definitions, then the purpose and scope of the cooperation, the organization of the cooperation, execution of the cooperation, subcontracting, the financing, confidentiality, restriction in use, intellectual property and access rights, warranty, liability, duration, termination of the project, miscellaneous, settlement of disputes, language, notices, applicable law and entire agreements amendments. And there are a number of exhibits connected to this PCA. First of all, the available background for the project, then an introduction of background subject to open source licenses, affiliated companies, and required contents of a request for approvals as referred in this Article 7.6.3. Just let's highlight a number of these articles. First of all, Article 2. In Article 2.4, two options related to background IPR are presented. Partners in a project have the possibility to identify which background they would like to introduce in the project. They have to describe that. And the second option they have is which background they would like to exclude from the project. Also, this needs to be described then in this exhibit. Article 3. In this article, the project coordinator is assigned and the project coordination committee, the PCC, is introduced. The PCC is an essential body to monitor and to steer the project and to make formal decisions. The PCC can take decisions, for instance, when a partner is not contributing as expected or not at all, for instance, and other partners want to remove this partner. Then, by voting, the PCC can decide to remove this partner from the consortium. But it can also be used to introduce new partners into the project. And for any other issue in the project which needs some formal decisions by voting. Article 4. Project partners can subcontract part of their work to third parties. So in some cases it's necessary, for instance in countries like Spain, Turkey, for instance academic partners are not funded in ITEA projects. So they can be subcontracted when they are necessary by other industrial partners into this project. This has to be described in this article. Then a very important article is Article 7. In this article, the IPR and the access rights are further specified in addition to the general IPR rules that are defined in the ITEA frame agreement. For instance, in Article 7.1, 3 options are provided for granting access rights for use, so for commercial use, commercial products, and one of them should be selected. The first option is that all parties agree that their contributions to the project are deemed to be balanced and access rights for use are granted on a royalty-free basis. So this means in fact that all partners contribute in the same way. They have the same contribution and therefore they can use the results freely among them. Also after the project for use. The second option is stated that all parties agree that their contribution to the project are deemed to be balanced and access rights for use are granted on a royalty-free basis, except for the specified parts. So if one partner has some specific parts which they are generating IPR for, and they do that on their own and they do not want to provide this as free to the other partners, then they can describe this in the exception of the specified parts. For these specified parts, fair and reasonable condition may be asked. So this partner can then ask the other partners, when they want to use it in their products, some contributions for that use. The third option is that all parties agree that their contribution to the project are not deemed to be balanced and access rights for use are granted on fair and reasonable conditions. So in this case nothing is freely available for the other partners, so all the IPR which you want to use afterwards, after the project, in your commercial projects, there you might have that you have to pay fair and reasonable conditions. Then the signature of the Pca template. All partners should first of all have signed the declaration of acceptance. The declaration of acceptance, it relates to the IFA, to the ITEA frame agreement, and therefore because of the link to the Pca it needs to be signed. For practical reasons, it could be recommended to have each company on a separate page for signature. The project leader can send out a set of pages equal to the number of partners for signature to each partner. Each partner signs then all the signature pages and returns all except one to the project leader. Then the project leader can distribute the other signed pages to the other partners. In this way, the signature process runs in parallel and can be faster, much faster than circulating the whole PCA among the different partners, because otherwise this can take a long time if you have to circulate it around. In several countries, the public authorities oblige that there is a signed PCA before the funding contract is made operational. So it is important that the project leader starts this process as soon as possible, and that all the other parties agree to the final PCA and do the signing of this PCA. For any more questions about this topic, you can use this email address indicated here. Thank you very much for your attention.